phone call you make, every message that you send or receive, or every email that you open, you think is invisible, you think is instant, and you think is private, or so you think. Imagine this for a moment, that within the vast telecommunications infrastructure in Nigeria, that a switch is flipped and everything you once thought was private becomes open and accessible. Only this time not by hackers or by criminals, but by the state itself, most especially network operators themselves, and on a legal ground. My name is Karimat Abdulazeez, and I am so pleased to give this video lecture on the lawful interception of communications in the Nigerian telecommunications sector. I am a graduate of Ekiti State University at Ekiti and a graduate legal trainee at HARLEM's Telecoms Academy, proudly sponsored by HARLEM Solicitors. I find this topic particularly compelling, and this is because it lies at the intersection of law, technology, security, and even human rights. Over the next few minutes, I'll be walking you through the following: the definition of interception or lawful interception of communication, the various types of lawful interception of communication, the legal frameworks that guides and govern the legal interceptions of communications in Nigeria, the authorities or the agencies that are authorized to legally intercept communications in Nigeria, the penalties for non-compliance with the laws and the regulations that guide legal interception in Nigeria, as well as the debate on whether or not the interception of communications in Nigeria violates the right to privacy of citizens. At the end of this lecture, I would expect you to understand the definition or the meaning of lawful interception in communication, to be able to state the various types of lawful interception, as well as to know the laws and the regulations that govern lawful interception of communications in Nigeria, to be able to state also the penalties that guides or that governs non-compliance of these laws and this regulation, and to also give your 2 cents on whether or not the interception of communications in Nigeria stands or violates the right to privacy of citizens in the country. Now, before delving into the topic of discourse, it is important that you understand that the Nigerian Communications Act 2003, hereinafter referred to as the Act, is the primary legislation, the primary law that governs communications in Nigeria. And by the express provision of Section 3 of the Act, it created and established the Nigerian Communications Commission, hereinafter referred to as the Commission, as an independent national regulatory authority that guides and governs telecommunications sector in Nigeria. Also, by the express provision of Section 70 of the Act, it grants and bestows upon the Commission the power to make and publish laws and regulations. It is in accordance with the provisions of this Constitution that the Commission, on the 23rd of January 2019, developed and issued the Lawful Interception of Communications Regulation 2019, hereinafter known as the regulation. The primary aim of this regulation is to state and specify the nature and the types of communications to be intercepted, and also the nature and the penalties of which can be given to the non-compliance of the provisions of the regulation. Now, what is lawful interception? According to Section 157 of the Act, which is also the interpretation section of the Act, it provides that authorized interception is an interception by the licensee of any network facility or any network service or application service that is permitted by Section 148 of the Act. Now, what does Section 148 of the Act state? It states that upon the occurrence of a public emergency and in the interest of public safety, the Commission can order any communication or classes of communication to and from any licensee regarding any specified subject matter to be intercepted. The Internet Society, on the other hand, defined interception, lawful interception, as the mechanism and the process of legally sanctioned official access to private communications of citizens. We talk about phone calls, we talk about email messages. And so it suffices to say that lawful interception is the legal requirement of an operator in the telecommunication industry to partake or to be able to access and be able to intercept specific and private communications of subscribers and users. Now, what are the various types of lawful interception? According to the provisions of the regulation, we are made to understand that there are 2 types of lawful interception. You have interception with a warrant and interception without the warrant. Now, dwelling on interception with a warrant, the provisions of Regulation 7 sub 3 of the regulation provides that a warrant is required in order to intercept communications whenever it is based upon these grounds, which I will mention. One, it is in the interest of national security. It is for the purposes of protecting, or it is for the purposes of preventing or investigating a crime. It is in the interest of public emergency and safety, and it's also for the in order to grant requests to international mutual assistance agreement. It is also for the protection and safeguarding the economic well-being of Nigeria. In fact, Regulation 7 sub 1 of the same regulation provides that a licensee can only act upon the warrant issued by the judge of the Federal High Court, authorizing and requiring that licensee to comply with the provisions of a warrant in the following instance. Now, based on this provision, such a licensee can, one, intercept any communications as may be described by the warrant. It can also disclose any intercepted communication in a manner that is also described by the warrant. It can also assist federal authorities in accordance with the International Mutual Assistance Agreement, of which Nigeria is a party to. But this has to be based on one foundation, that there is no other lawful means whatsoever in order to investigate the matter for which the license, for which the warrant is required. Now, it suffices to note that a judge of the Federal High Court cannot issue a warrant if such warrant unless such warrant is necessary, and unless such information must be lawfully intercepted in order to gain the relevant information from that particular communication. Moving on, I would like to address the fact that in order to talk about the application for a warrant, Regulation 12 of the regulation provides that for the application of a warrant to intercept a communication, an application has to be made to the judge by the following agencies. Number one, the Office of the National Security Advisor, represented by the National Security Advisor himself or by his designee, who would not be below the equivalent of an Assistant Commissioner of Police, as well as also the State Security Service, represented by its director or its designee, who is also not supposed to be below the equivalent of an Assistant Commissioner of Police. Note that where the application of a warrant is for or on the basis or on the grounds related to international mutual assistance agreement, that particular application must be made by the Attorney General of the Federation. Also, it is important that I bring to your understanding that the application for a warrant must be in writing. It must contain the particulars, the full particulars of the facts and circumstances alleged by the authorized agency. It must also be accompanied by an affidavit on oath that states that that particular interception is the only lawful means of gaining the required information. It must also be on the grounds that has been explained before, contained in Regulation 7 sub 3 of the regulation. Now, we move to interception without a warrant. Under this type of interception, and based on the express provisions of Regulation 8, it provides that interception of communication by any person would be lawful in the following events or under the following circumstances. One, that one of the parties to that particular communication has consented to the interception. However, it must be on the ground that there is an infallible proof of that consent and it must be available. Also, that it is also done by a party who in that particular instant has sufficient reason to believe that there is a threat to human life and safety. And lastly, that in the ordinary course of business, that particular conversation is supposed to be intercepted or monitored. Now, I would also like to bring to your concern or bring to your notice that also according to the provisions of Regulation 12 sub 4, it provides that authorized agencies can initiate an interception without a warrant and it will still be legal on the following basis. One, that there is a danger of death and there is a serious injury. Two, that the activities therein threatens national security. And lastly, that the activities has characteristics or features that can be likened to features of an organized crime. However, For this to be lawful and to be bestowed on the grounds or the foundation of legal basis, such application for a warrant must be done within 48 hours after the interception has occurred or begun. Where this is not the situation, or where this has not been done, such interception must be terminated immediately. Where this is not done, any further interception whatsoever will be considered and treated illegal. Now, we go to the legal frameworks that governs lawful interception in Nigeria. Nigeria over the years has espoused and enacted laws, regulations that guides and govern lawful interceptions of communications in Nigeria. Some of which include the 1999 Constitution of the Federal Republic of Nigeria as amended, the Cybercrime Act of 2015 as amended in 2024, the Terrorism Prevention Act of 2011 as amended in 2013, the Nigerian Communications Act of 2003, and lastly, the Lawful Interception Communications Regulations of 2019. Now we go to who are those agencies that are authorized to intercept communications. Regulation 23, which is the interpretation regulation of the regulation, interpreted authorized agencies as the following person. One, the Office of the National Security Advisor, the Nigerian Police Force, the State Security Service, the Economic and Financial Crime Commission, as well as the National Drug Law Enforcement Agency, and whatsoever agency that the Commission may from time to time publish or specify. Now we go to the next basis or the next module of this video lecture, which is about the penalties for non-compliance with interception rules or with the provisions of the regulations. Pursuant to Regulation 16 of the regulation, it provides that in the event of non-compliance by any person or by any licensee, such a person or such a licensee would be liable to a fine of 5 million naira only. However, where such offence is allowed to continue, that same licensee or also that same person will further be subjected to a penalty, a daily penalty of 500,000 naira daily for each and every day that that offence is allowed to continue. Also, the commission has the power to revoke the license of the licensee in accordance with the provisions of Section 45 of the Nigerian Communications Act 2003. Now, this provides for the suspension and the revocations of licenses. Moving on, the Commission can also initiate actions by way of injunction, specific performance, and also by an order of the court to serve as a means of enforcing compliance. And lastly, whether or not lawful interception violates the right to privacy of citizens in Nigeria. This particular subtopic has been in the domain of academic debate for years. However, within the next few minutes, I would like to understand and going from the basis of the provisions of the law to determine whether or not lawful interception violates the right to privacy of citizens. Chapter 4 of the 1999 Constitution of the Federal Republic of Nigeria as amended guarantees and contains certain fundamental rights, including the right to private and family life. Now, this is contained under Section 37 of the same Constitution, and this provision covers the homes of citizens, their correspondence, their phone conversations, and their telegraphic communications. In this situation, however, I would like you to understand and to bring to your notice and knowledge also that this particular right is not absolute, as it has been moderated by the provisions of Section 45 of the same Constitution, which provides that nothing in Section 37, 38, 39, 40, or 41 of the Constitution shall invalidate any law that is reasonably justified in a democratic society, especially when such law is in the interest of defense, public health, public morality, public order, and also public safety. Also, when it is for the protection or the provision or security of the fundamental rights and freedom of other citizens. As such, we can come to the conclusion to state that a law or a regulation that infringes or impedes on the enjoyment of the right to privacy can be made, and it will also be lawful, so long as it is reasonably justified in a democratic society, and it is in the interest of justice, it is in the interest of public health and defense. Now, it is based on this that I would like to also bring to your notice, because this is, of course, a video lecture, that the aim of the Lawful Interception of Communications Regulation 2019 is to protect public safety, security, and national defense. As such, the regulation itself and any action taken pursuant to the regulation cannot be said to be in breach of the provisions of Section 37 of the Act. And this is because it falls under the ambit and comes under the exception allowed under Section 45 of the Constitution. Now, you would agree, based on this explanation with the backing of the law, that lawful interceptions of communication does not in any way infringe on the right of privacy of citizens. Conclusively, we understand that lawful interception in Nigeria presents as a delicate equilibrium, protecting the rights, that is, especially the right of privacy of citizens on one hand, and also defending the national security of the country on the other hand. Of course, and obviously, Nigeria has made commendable efforts in espousing legislations and regulations in order to combat and in order to govern the lawful interception of communication. But the one true test of this all is enforcement. Thank you very much.